There was an article today about which began with a reference to Sarah Palin, and her claim that the NHS had death panels was part of a broader critique of government-run healthcare, specifically in the context of the 2009 US debate over the Affordable Care Act, or Obamacare, and her statement was based on a misinterpretation or a deliberate distortion, who knows, of end-of-life counselling provisions in the proposed US legislation, which she argued would lead to bureaucratic rationing of care and decisions about who could live or die. And Palin, in an August 2009 Facebook post, wrote that under Obamacare, government bureaucrats would decide whether they are worthy of health care. And she later elaborated, claiming that such policies already existed in the UK's NHS and other socialised healthcare systems, implying that panels of officials decided who was too sick or too old to receive treatment. Palin's reference to the NHS was likely tied to NICE, which sets cost-effective guidelines for treatments in England and Wales, and NICE evaluates the treatments or the benefits of treatments used on quality-adjusted life years, a metric used to determine whether the NHS should fund a particular drug or a procedure. And this system, designed to balance cost and medical benefit, was misrepresented as a death panel that denies care to the elderly and the disabled. And of course, all hospitals have these meetings where planned surgery is discussed and prioritised. Another possible interpretation of her claim was the Liverpool Care Pathway, a now defunct protocol for end-of-life care in NHS hospitals, and the LCP was meant to provide dignified care for terminally ill patients. But after concerns about misapplication, where some families felt their relatives were placed on it without proper consultation, it was phased out in 2014. Palin's phrase was widely criticised as misleading, but proved effective as a political talking point. The term death panels became a rallying cry for opponents of government healthcare, fueling fears that the ACA would lead to rationing of care and state-mandated euthanasia, despite the fact that the provisions in question were voluntary discussions about end-of-life preferences between patients and doctors. In reality, the NHS doesn't have death panels in the sense that Palin suggested. Instead, it certainly has advisory bodies that guide funding decisions based on medical efficiency or efficacy and cost effectiveness. Efficacy, efficiency and cost effectiveness, something not unique to the UK but found in many healthcare systems, whether acknowledged or not, including private insurance models in the US. And so this storm, this term, generated an international firestorm, this term, the death panels. And at the time, as I say, it was dismissed as scaremongering, a grotesque caricature of the UK's healthcare system. And yet 16 years on, Kim Ledbetter, the MP, appears inadvertently to be proving Palin right. The Labour MP's assisted dying bill, which once promised judicial oversight by a High Court judge, has now morphed into a system governed by an expert panel. What is that, except for the death panel? A change and a charge that has alarmed critics and emboldened opponents. It's as if Kim Ledbetter is so desperate to get this bill through at any cost that she will sacrifice whatever things that she had thought were essentials before, simply to get this moving forward. Her bill had proposed that each case of assisted dying should be scrutinised and signed off by a High Court judge, and this, she insisted, would provide the strongest safeguards in the world, ensuring that vulnerable individuals were not coerced into ending their lives. However, as parliamentary scrutiny has progressed, she's performed a remarkable volte-face, replacing the judicial sign-off with a voluntary assisted dying commission. And this body, chaired by a King's Counsel or a retired judge, would appoint a panel, including a psychiatrist and a social worker, to make a final decision. The reason? The sheer impracticality of involving the High Court in every case. As former Supreme Court Justice Lord Sumption has pointed out, such judicial oversight would be largely illusory unless judges conducted exhaustive, time-consuming reviews of each individual application, and the backlog in England's courts, particularly in family and administrative cases, mean that people seeking assisted dying might expire of natural causes before their applications were even processed. The amendment, Ledbetter insists, is a necessary response to expert testimony. Critics are not convinced. Conservative MP Danny Kruger, a staunch opponent of the bill, called the change deeply concerning, and he and other sceptics have argued that the judicial element was central to securing parliamentary support at the second reading. Over 60 MPs cited it as a critical safeguard, and with it now removed, some are reconsidering their backing. It would take just 28 MPs switching sides to overturn the bill's majority. Even within Labour, divisions are evident. Diane Abbott dismissed the move as rushed and badly thought out. Florence Eshalomi called it worrying in the extreme, and other critics warn that expert panels, likely self-selecting from those sympathetic to assisted dying, would lack the impartiality of the courts. Ledbetter insists that panel members would be chosen through a rigorous neutral recruitment process, but trust in the bill's robustness has already been eroded. One of the most striking aspects of the bill's trajectory is its speed. And unlike previous efforts to legislate assisted dying, which have stalled or been defeated, this bill is moving through Parliament with remarkable ease. The Commons passed it at a second reading with a decisive majority of 55 votes. The Lords, historically more sympathetic to such measures, are unlikely to block it. Concerns about parliamentary oversight extend beyond the judicial question. The Hansard Society has raised the alarm over the bill's provision allowing the Health Secretary to determine what drugs may be used for assisted dying, and under current drafting, MPs would have no direct vote on this crucial issue, despite its obvious ethical implications. Critics fear that giving ministers discretion over life-ending substances risks politicising the process and lacks the transparency such a momentous decision deserves. At its heart, the debate over the assisted dying bill is more than technical safeguards. It's about the fundamental question of whether authority figures, judges, doctors, panels, should have the power to determine when and how a person may die. The bill's defenders argue that the combination of a two-doctor sign-off and the new expert panel will prevent coercion and abuse. Opponents worry that the bureaucratic safeguards will be at best a costly mechanism for legitimising the taking of a life, and at worst a slippery slope towards normalising assisted suicide for the vulnerable and the elderly. And Parliament has been here before. Previous assisted dying bills have faltered on the moral minefield that they present. MPs and peers have historically feared unintended consequences, the erosion of palliative care, pressure on the elderly and disabled to stop being a burden, and the subtle shift in medical culture from preserving life to facilitating death. Even with the strongest safeguards, these risks cannot be entirely eliminated. And despite the controversy, the bill looks set to pass. Many MPs who backed it at a second reading did so with a full awareness of the complexities involved. They will likely view the expert panel as an adjustment, not a betrayal. And the government's official position, one of neutrality, means that there is no coordinated effort from ministers to halt its progress. Where Streeting, the Health Secretary, opposes the bill but has remained largely silent on its latest developments, and Junior Minister Stephen Kinnock offered only platitudes about operationalism when questioned. Or operationalisation, that's it, operationalisation. What a word! For those who support the bill, its progress is a triumph of compassion over dogma. An overdue reform that gives the terminally ill control over their fate. For opponents, it's a rushed and dangerous shift in end-of-life ethics, carried forward by procedural shortcuts and vague promises of extra levels of scrutiny. And I'm not convinced that those extra levels of scrutiny are really there. Kim Ledbetter insists her bill remains the most robust in the world, but as Parliament edges towards approving assisted dying, the question remains: can any set of safeguards truly make such a fundamental change in the law watertight? And if not, is this a step the UK is ready to take?